How's it going, everybody? I'm making this video for those of you that have gotten red light camera tickets. I believe that's what they're called. I don't know. Never got one myself. But I'm making it because I've had too many of you call me and ask me, oh, hey, I got a red light ticket, blah, blah, blah. And I've never really fought these as much as with infractions, Don't have that much experience. I have some, but the point is, I've seen some cases where, some of you are behind the line. It still takes your pictures. I don't know how that works, but you guys got it. Some of you are actually on it, and some of you just barely passed it. And of course, that's $500 in some cities and only $400 in others. When in fact, by law, from what I've read, it should be only $200. But I digress. The point is that there was this guy here who fought this ticket for about 2 years. Reminds me of me because he started in 2008, where 2 of my tickets were 2008, and we just got this decision in May 25th, 2010. My decisions will be coming around 2010. So, if this guy had just quit like most of the people do and said, you know what, this ticket's only $500, it's going to take me 2 years, I can make that in a month. I'll be losing a lot of money every time I go to court. Well, guess what? This guy had the courage to do what he did. And because of him, we actually now have case law supporting how traffic ticket camera, these camera traffic tickets, whatever the hell you want to call them, or photo enforcement, are inadmissible as evidence in court, whether they're photos or videos. So thank you, Mr. Khaled. Okay? This came back May 25th, 2010. Once again, I'm going to put up the appellate case number because unlike the straw man and accepted for value and other stuff, I actually have court cases where you guys could verify and expose if I'm lying. Which I'm not, so I'm not worrying about it. Unlike some others, that's why they don't put the case numbers up. So here we go. And this is in the city of, or county of Orange. Okay, now let's get to the point here. Okay. Alright. Let's get to the facts here. Alright. Here we go. Basically, they try to enter into evidence that the photographs and the videos, and so appellant objected introduction of the photograph and declaration as inadmissible hearsay and violative of appellant's confrontation rights. The objection was overruled and the trial judge admitted the photographs as business records, official records, and because a proper foundation for the admission had been made based on the submitted declaration. So now basically, and let me make a comment real quick about this. I've seen this all the time. For people that have actually filed valid motions to dismiss or motion to suppress, motion in limine, I've seen judges tell me, for example, oh, it's frivolous. I can't understand what this says. You're not citing anything here. Even though I've had Supreme Court cases and stuff like that. So the better your stuff is, the more likely they'll say that you don't understand it or that it's garbage. And the crappier it is, the more they'll entertain it and say, oh, okay, well, we'll give you another date and we'll do, so this is exactly what they did to him, which is a tactic, so you can, pretty much think you're not doing what you're supposed to be doing and just give up. It's a psychological ploy. Then it says, we hold that the trial court erred in admitting the photographs and the accompanying declaration over the appellant's hearsay and confrontation clause objections. Absent the photographs and content in the declaration, there is insufficient evidence to support the violation. Accordingly, we reverse the judgment. So he appealed, like I'm going to do with this Glendale judge. And, because they'll do whatever they want at the bottom, they just know most of you will not fight all the way to the top because it takes time. And some of you just don't have it, which is understandable. And they know this, so that's why they do it. Factual summary. The underlying facts in this case are fairly simple. No police officer witnessed the alleged traffic violation. Instead, a police officer testified about the general area depicted in a photograph taken from a camera installed at an intersection in Santa Ana. A particular private company contracts with the municipality to install, maintain, and store this digital photographic information. The officer testified these photographs are then periodically sent back to the police department for review as possible driving violations. To be more specific, the photographs contain hearsay evidence concerning the matters depicted in the photograph, including the date, time, and other information. The person who entered that relevant information into the camera computer system did not testify. The person who entered that information was not subject to being cross-examined on the underlying source of that information. The person or persons who maintained the system did not testify. No one with personal knowledge testified about how often the system is maintained. No one with personal knowledge testified about how often the date and time are verified or corrected. The custodian of records for the company that contracts with the city to maintain, monitor, store, and disperse these photographs did not testify. The person with direct knowledge of the workings of the camera computer system did not testify. Instead, the prosecution chose to submit the testimony of a local police officer, Santa Ana Police Officer Alan Berg. This witness testified that sometime in the distant past, he attended a training session where he was instructed on the overall working of the system at the time of the training. Officer Berg was unable to testify about the specific procedure for the programming and storage of the system information. Here is where it gets interesting. Because some of you will say, well, now there's video and you can use that. Well, shut up and listen. Admissibility of videotape and photographic evidence. These photo enforcement cases present a unique factual situation to the courts regarding the admissibility of videotapes and photographs. There are two types of situations where a videotape or photographs are typically admitted into evidence where the photographer or videographer does not testify. The first involves a surveillance camera at a commercial establishment, oftentimes a bank or convenience liquor store. In those situations, a person testifies to being in the building and recounts the events depicted in the photographs. In other words, a victim, a witness. Courts have consistently held that such testimony establishes a sufficient foundation if the videotape is reasonable representation of what it is alleged to portray, of course. Then this case law here. Okay, then it goes, the second situation involves what is commonly known as a nanny cam. In that situation, a homeowner hides a surveillance camera in a room and then retrieves the camera at a later time. At the court proceeding, the person establishes the time and placement of the camera. This person also has personal knowledge of when the camera was initially started and when it was eventually stopped and retrieved. So they have to have personal knowledge. Neither of these situations is analogous to the situation at bar. Here the officer could not establish the time in question, the method of retrieval of the photographs, or that any type of the photographs or the videotape was reasonable representation of what it is alleged to portray. A very analogous situation to the case at bar, however, is found in Ashford versus Culver City, where the court held that unauthenticated videotape allegedly showing employees' actions lacked sufficient foundation to be admitted at an administrative hearing, and in so holding, the court noted that without establishing such a foundation, the videotape was inadmissible. So you guys know, here you go, this is where it says right here, official records exception evidence code, and still does not apply. Okay, and then it basically, okay, people versus whatever, it says right here, police report containing contents of official record or report without necessarily requiring a witness to testify. So these are the exceptions, okay. Here the record is totally silent as to whether the trial court took judicial notice of anything, nor does it show sufficient independent evidence that the record or report was prepared in such a manner to assure its trustworthiness. The only evidence outside of the contents of Exhibit 3 describing the workings of the photo enforcement system and a recordation of information from that system came from Officer Berg, who admittedly was unable to testify about the specific procedure from the programming and store of the system information. So here you go, guys. Hopefully you guys enjoy this video and it helps you. And so it says right here, accordingly, without such foundation, the admission of exhibits 1 and 3 were erroneous, and thus the trial court abused its discretion in admitting these exhibits. Without these documents, there is a total lack of evidence to support the vehicle code violation in question. The judgment is reversed, and with directions that the charge be dismissed. People versus Biggie Natty. Enjoy, guys.